We're ready.
Thank you, Your Honor. May it please the Court. Michael Lufferman on behalf of the appellant Eugene Hwang. I'd like to reserve 5 minutes of my time for a rebuttal. I'll focus my time this morning on the first claim raised in the briefs, and that is whether the trial court erred by denying the request to redact a particular hearsay statement from the recordings of the conversations between the alleged victim and my client. Now, after the incident in this case, there were several conversations that were recorded between the alleged victim and my client. One in particular, several were objected to. One in particular that's the focus of the brief was played during the trial over objection. And that statement was as follows, and this is on page 450 of the record, or 450 of the trial transcript. And the alleged victim says during the recorded conversation, "I'm pretty sure I remember Kim Young saying not to do it." And my client responds, but the response is inaudible. And then the alleged victim again says, "So why did you do it even if your friend told you not to do it and he doesn't even know me?" So this is an alleged sexual battery. Mr. Young was supposedly in the hotel room at the time of the sexual battery. And the objection here is that that's clear hearsay. Mr. Young did not testify at trial. We have no idea whether he ever said that.
Why isn't this like so many cases, including I think the state McWaters, where the detectives are saying, well, you know, your co-defendant said this. That's always been, almost always, has said, look, that's not being offered for the truth of the matter, it's to show the defendant's reaction to it. Why isn't this the same thing?
So, and again, the state's offered several reasons. One, to try to show his state of mind, and I'll address that in a second as well, but they're also trying to say, oh, this was to show his reaction in the context of the recorded conversation. You know, I submit that, again, this is clear hearsay. Sometimes law enforcement may be able to do that, and sometimes courts may say it's okay in the context of the situation. In McWaters, the one thing I would note is the Supreme Court went out of its way to highlight that the judge specifically gave a limiting instruction that told the jury, no co-defendant ever made that statement. You're not to consider the truth of the matter asserted. You're only supposed to consider that for the purpose of the impact or the effect that it had in his reaction.
Was that requested in this case?
No, I think the argument from defense counsel would be, I don't want it in at all. So the case law doesn't require the defense to request a limiting instruction in order to preserve an issue for appeal. I think the limiting instruction, had it been given, had the state said, Judge, to be safe, let's give that. We're not trying to say that Mr. Young actually said this. We're only putting this out there to show his reaction to it in the context of the recorded conversation. Then perhaps in a harmless error situation, they could point to that and say, look, the jury was specifically told Mr. Young didn't say that. They're not to consider it for the truth of the matter that he actually did. They're only supposed to consider it for his reaction. Jury was never told that. This jury went to the jury room believing that my client's friend, who didn't know her, as she says, supposedly said right at the time of the incident, don't do it. And why did you do it even though he told you not to do it?
What was the defendant's reaction during that recorded conversation when she said that Mr. Young said not to do it?
I think he changes subjects and he kind of avoids the question and talks about something different. During his conversation with her, he acknowledges that they did in fact engage in sexual activity. He says that we did have sex for a short period of time, you told me to stop and I stopped. Now, of course, he didn't tell that to law enforcement. As defense counsel argued during closing, it's not a crime to not tell the police the truth during an interrogation. But during the recorded conversation with her, he specifically acknowledges, yes, we did engage in sexual activity. You told me to stop, and I stopped. Her claim, of course, was that, no, I told him to stop, and he didn't stop.
Right. But I'm trying to understand is when the court let in that hearsay statement of Mr. Young that
Kim Young said not to do it.
Right. What was the defendant's reaction? I mean, did he give a reaction that was exculpatory, or did he just not respond? I'm just trying to understand the evidence. I'm trying to understand the evidentiary value of allowing that statement in. The statement that Mr. Young made during that recorded conversation.
And the other problem with this case is so much of what was played was inaudible, and that's reflected in the transcripts, but it goes on to say, Mr. Hwang, no, I wasn't inaudible. I never inaudible. We didn't do anything inaudible. I promise you nothing happened, and nothing happened, I promise, because I knew inaudible to try to stop. I'm not even sure that I can give you the context of what he was saying in response to that. I do know later on he specifically says, yes, we had sex for a brief period of time. You told me to stop, and I did. And that's, of course, what the defense was during closing. My client was charged with 3 counts, kidnapping and 2 counts of sexual battery. The jury found my client not guilty of kidnapping. The jury found my client not guilty of one of the sexual battery counts. Clearly, the jury was trying to weigh the evidence, and they didn't believe everything that the state was presenting. They didn't find my client guilty as charged for all 3 counts. They didn't even believe her regarding the 2 alleged sexual batteries. So this was a credibility contest between, do they believe her when she says that I told him to stop and he continued, or did they believe my client when he says, you told me to stop and I did stop? That's the issue for them to decide. And if in any way they went into that jury room and relied upon my client's friend who's there supposedly telling him not to do it and he nevertheless did it, then that tipped the scales in favor of the state and made it so my client couldn't get a fair trial.
I mean, I'm looking at record page 534, which is PDF 686, and your client says, but you told me to stop, you kept on telling me, but I kept on going. Not because I knew I was doing something wrong, but because I wasn't doing anything wrong other than trying to seduce you. But he said, I kept on going after you told me to stop.
I think, in context, Your Honor, and I'll look at that more and I'll respond to that in rebuttal, I think he made that comment regarding the evening about them being back and forth and kissing on the neck and things along those lines. I'm reading on that same page, because of you leaning on my shoulder and like kissing me on the neck while I was drunk, that tipped me off okay, and that made me feel like, made me have the temptation. So I think they're referring to things that were happening earlier in the evening. These 2 started out, I think the alleged victim came to my client's restaurant where he was working. They then went to a karaoke bar, and then that's where they were consuming drinks. And it was at that point that my client's version is that he knew that she was too intoxicated to drive, and they felt that it was best to take her to a hotel room close to where she lived so she could sleep it off. He went into the hotel room with her, and that's where the incident occurred, that she's claiming that it was rape, and he's saying that it was consensual until the point that she said stop, and that's when he stopped.
What about the little video, which is very short, but does...
Your Honor, I don't see any value for the state in that video. That lasts about 2 seconds. I don't hear the word stop. I heard, these cases are graphic and I apologize. I think the defense has described whatever that initial sound was as some type of moaning.
But doesn't the video show ML, the alleged victim in this case, trying to push him off of her?
I can't see that. I mean, it is like that. It is that fast, and he may have his hand on her leg, and she may be taking his hand and doing something with it. It certainly doesn't last long enough for us to see what she's doing with his hand and directing his hand to do from her hand. Again, it's like this. You hear a noise that I can't discern as being the word stop. Defense counsel argued in closing that it wasn't the word stop. The defense counsel argued that it wasn't the word no. And so I think I can go either way, but that is such a short snippet of what happened during this evening. Even if it's her saying stop, and he did stop at that immediate point in time, that would be consistent with his theory of defense, which is you told me to stop and I stopped. There's nothing in that video that shows that she's supposedly saying stop and he continued to do anything. It only lasted 2 seconds. So there's no way that video supports the state's theory more so than it supports the defense's theory. I don't think that has value one way or another. Certainly doesn't defeat the claim or establish that this claim would be harmless error. Again, we have my client's friend sitting there supposedly saying, he told you not to do it. Our courts don't allow the state to introduce evidence from someone who doesn't testify for the proof of the matter asserted. For the
I think it's a little different than he told you not to do it.
I remember him saying not to do it.
He was saying not to do it.
Correct.
So therefore, it doesn't come as in for the truth of the matter asserted, but rather perhaps for whether or not it was, as your client says, it was a consensual encounter as opposed to a crime. So therefore, it's not for the. That's the argument. How do you respond to that?
So the state of the mind of my client. If that's what you're asking, Your Honor, that's certainly what the state. That's one of the other reasons that the state has asserted that this is not hearsay. And from what I can tell, they said one was the context from based on his reaction. We've talked about that already. They've also talked about the state of mind of ML. As I've argued in my brief, I don't see.
Your defense is that it was consensual.
Correct.
Until she said stop, and then he complied.
Yes, that's exactly what the defense was.
Okay, so if this statement came in with the idea of showing that prior or contemporaneous with this action of this happening, he had said this, then it wouldn't prove whether or not he had, what of the context of what he said, but whether or not he said what the defendant said in reaction to it.
What would be the relevance of that? I mean, I think the reaction to it would clearly go to the truth.
You tell me?
I can't see how there's relevant in any way whatsoever. So Professor Earhart talks about this particular state of mind exception, the state of mind of the hearer or the listener to a statement being made. The examples that Professor Earhart gives are almost always hearsay that lead to something that the state can use as motive. The Smith case is something that Professor Earhart cites to. The state cites to a case called Eugene from this court that's that exact scenario. In Eugene, it's a first-degree murder case, and the hearsay in question, or the alleged hearsay, was an email from the alleged victim to the defendant saying, our relationship is over. And when the state introduced that statement during the trial, the state said, we're not introducing this to show that the relationship was actually over. We're simply introducing this to show that he received this email saying that the relationship is over, and that was his motive to therefore follow through and murder her. That makes sense to me. Simply saying that, oh, this guy is there and he supposedly says not to do it, I don't see how that has an impact on my client's state of mind. We don't even know if that statement was said, and trying to see what his reaction would have been at the time. Again, it's not even a true statement as far as the defense is concerned. They never got to cross-examine Mr. Young to see if he even said it. So if you want to figure out what his reaction was when that's being said in the context of the recorded conversation, we've talked about that. His reaction is nonsensical. It kind of changes subjects and doesn't really say one thing or another about that. If that's what the state wanted to get it in for, I don't see how that's relevant. It certainly, he doesn't admit to it in response to that, and that wouldn't be relevance on their part. And again, the probative value of this is far outweighed by the prejudice. At the end of the day, there's no instruction in this case. The jury doesn't hear anything about what Mr. Young said except for this. Mr. Young didn't testify. He never came in. My client never got to confront him on this, and yet the jury's left with the impression that as this incident is supposedly occurring, he supposedly said not to do it. And she goes further. Why'd you do it even though your friend told you not to do it, and he doesn't even know me? And if the jury's thinking, this is close, we're going to find him not guilty on one of the sexual battery counts, we're going to find him not guilty on the kidnapping count, but I'm not sure about the other one. This is the one that's the penile penetration that he was found guilty of. And he's acknowledged that they did in fact have sex. He said he stopped when she told him to stop, but well, what about that friend? We heard that friend said not to do it. And maybe that's what causes us to say, yeah, he's guilty. And they can't consider it for that purpose. They're never told, don't consider it for the truth of whether Mr. Young actually ever even said that. Because in their minds, they're going to be thinking that, and that's why my client didn't get a fair trial. He should get a new trial where that statement doesn't come in, or Mr. Young should be called in to testify so my client can have a chance to confront him. Thank you.
Thank you.
Good morning, and may it please the court, Matthew Oxrider on behalf of the state. I'd like to direct the court's attention to electronic record page 653. The victim in this case wasn't the only person to state that Kim Young said, I told you not to do it. In fact, the defendant on that page admitted he, quote, already took a beating from Kim Young after that night. I told you not to do it. Now he then sort of like tries to backtrack that statement because the victim seizes on it and says, he told you not to do it. And this is later than the first controlled call. This is during the controlled meet. But it's clear from the record that the defense, or the defendant, didn't contest that this statement occurred. He tries to then put it in perspective. But turning to the McWaters issue, the statement's just offered simply in this case to put the response from the defendant, which is no, and then he sort of denies any sexual contact occurred that night. You have to put all of that into perspective, otherwise it's just sort of like a faceless statement, or there's no context. And McWaters makes it clear that these other statements come in to provide context to the defendant's statements. And I think it's telling that in the second controlled call, there are several statements referenced about the defendant's girlfriend that are not challenged at all as hearsay, where she attempts to get the victim to not press charges. Why would she do that? I mean, it doesn't matter why she would do that. It's trying to provoke the defendant with certain responses. And that's exactly what this was admitted for here.
Did you take a look at the video in this case? I mean, because we got the impression that it did show the alleged victim in this case trying to push the defendant away and also telling him not to stop.
To stop.
Telling him to stop.
I think what's clear from the video, and I have watched it, is she says, get off me. Now, she testifies at trial, and there was some debate, Mr. Ufferman is correct on that, as to what the preceding words were, whether it was a moan or whether it was stop it. Now, the video kind of cuts in and out. Obviously, for whatever reason, I'm not sure that's in the record, but I think we can all imagine. But the key there is she does say, "Get off me." Now, what's important to note about that is, I think in the overall timeline of this crime, they were in the bed. The defendant is on top of the victim. She says, "Get off," and it's up for interpretation. I think it's a fair issue for the jury whether she was pushing or not, although that's not required for a conviction of sexual battery. And at that point, it's clear from ML's testimony, she tells him, "I need to vomit. I need to go to the bathroom and vomit." That's after what happens in the bed. They then go to the bathroom where she's vomiting, and the defendant, and this is on page 689 of the electronic record on appeal, the defendant admits at that point, while she's vomiting, to attempting to have sex with her at that point, to putting his penis inside her vagina at that point.
Is that the one he was convicted of then?
Correct. I mean, the penile penetration is what he was convicted of.
Right,
Just
so
correct.
the one on the bed,
Well, right, it's not clear whether any penetration occurred, I guess, at that point, but the admitted penetration occurred over the toilet where she was vomiting. The physical evidence backs that up. There's vomit in the toilet when the police come to take pictures. And so as to any other counts that maybe there were acquittals on, the digital penetration or the kidnapping, it remains to be seen that the defendant in this case admitted that there was penetration over the toilet
while she was vomiting.
while she was vomiting. So it's our position that the statement from Kim Young is completely admissible, but otherwise would be harmless beyond a reasonable doubt. And if there aren't any further questions, the state would ask you to affirm as to the first 2 points and reverse, because the score sheet needs to be corrected to reflect that this was actually a second-degree felony, not a first-degree felony, and there's an out-of-date statutory reference on the judgment. Thank you.
May it please the court. Referring to my client's statement on page 501 of the trial transcripts that the state
Do you have
referenced.
the electronic record reference to that?
I don't, Your Honor. I just simply have it's page 501 of the trial transcript, which is volume.
Just as a point,
Volume 7.
that doesn't help us because we're all electronic up here, and so in the future, when you're doing your briefs, make sure you give us the electronic.
Of course, Your Honor.
And when you're standing up here, so I can look at it. I'll try to
I
find it.
apologize.
501.
501, it's the upper right-hand corner of the trial transcript.
Yeah.
And at that point, when she says, "Did he tell you not to do it," or he told you not to do it, his response was, "No, he didn't tell me not to do it with you." So I have two responses to that. Number one, the pretrial objection was to anything about Mr. Young from these recorded conversations about whether he said to do it or not. So at that point, the judge has overruled that, and those statements are coming in. This is a separate statement. I would submit that's covered by counsel's objection to allowing this type of statement in. And so it came in because the judge allowed it. If the court agrees that that statement should not have come in, this is another statement that also shouldn't have come in as well. But his response to this is specifically, "No, he didn't tell me not to do it with you. He just said, I don't want to do it," and starts talking about the evening and his involvement in the entire evening, but not, "He didn't tell me not to have sex with you." That's his exact response at that time. Again, as far as what the jury convicted my client of, the alleged victim in this case has alleged several different incidents of potential sexual battery, both penile and digital. And of the penile, it potentially could have occurred on the bed and also could have occurred in the bathroom. What we know my client admitted to is simply that, yes, there was penile penetration, but you told me to stop and I stopped. That's what he said in the statements to her. And if the jury believed that, he's not guilty of a crime. And if the jury relied upon Mr. Young's statements that he told you not to do it and you nevertheless did it, that's improper, and that's why he didn't get a fair trial. It's hearsay. It should not have been allowed in. The judge clearly considered this objection and said, "I'm going to allow it in." There's no exception to the hearsay rule that would allow this in, and I'd ask this court to reverse to give my client a fair trial. Thank you.
Thank you. Thank you both. We will be in recess.